I'm sorry for the delay. Mr. Christopher Lewis, are you there?
Yes, how you doing?
I'm very good.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing. Okay,
I apologize.
Thank you.
All right, today is the date. Good morning, Mr. Lewis. Today is the date and time set for a hearing on the bench warrant. I'm going to enter a not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't know anything about Zoom.
I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Okay, I'm resending it at the moment.
I'm gonna put my email address in the chat and I'll put my email so you'll have it. And send that to me, and I'll have an opportunity to read that. I'll confirm that you sent. I'll wait to confirm that you sent it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment. If she could send me a confirmation that she received it.
Get it to her email address.
Hey guys, welcome to today's video. Today we're diving into a courtroom standoff that goes sideways fast. It all begins with what seems like a routine hearing until Mr. Lewis insists he never missed court and was actually locked out. For an entire hour, the judge searches for missing motions while both sides scramble to exchange emails. What starts as simple housekeeping quickly turns into rising confusion and tension.
Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, of both motions that it has. All right. I'm going to wait on that. Once I confirm that you gave me that, I will recall the case. All right, let's pass that matter. Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter.
As the judge returns, he admits he skimmed only the first lines of Lewis's motion, triggering an immediate push back. Lewis presses him hard, demanding the full document be read and requesting a written explanation for the denial, but the judge refuses, cutting the moment short with a firm rejection. The gap between them widens, setting the stage for a deeper clash over due process and fairness.
Can I get a written articulation as to why you're denying the motion?
I'm denying the motion,
I would just appreciate
because
a written excuse. Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying that.
I'm saying that no, there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying a motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I can take that to the tenor. Okay.
Well, you can insist all you want to.
Lewis pivots straight into constitutional territory, asking whether the court is bound by the U.S. Constitution. He argues Fourth Amendment violations, accuses the judge of denying due process, and even challenges his authority by calling for a real judge and a change of venue. The judge denies everything as Lewis warns the situation is heading toward malicious prosecution, escalating the confrontation.
I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing. That's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there, overwhelming. So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no victim or no loss, bro.
I'm not. Listen. I'm not.
Look, sir. Hey, sir. Respect.
The confrontation intensifies as Lewis accuses the court of bias, profit, motives, and conflict of interest. He challenges the entire foundation of the case, pressing the judge nonstop. That's when the judge finally snaps, demanding respect and warning Lewis not to interrupt again. The courtroom's tone shifts instantly from argument to a stern warning that draws a line Lewis is clearly testing.
You're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody. I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence, or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, cool. It's cool. I appreciate it. This is due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. if you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You
Okay,
take
let's do
whatever.
Christ the tenor.
Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
I appreciate that, but I would still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any.
Trying to redirect the chaos, the judge offers Lewis a jury trial, but Lewis pushes for written explanations and claims he can't even reach court staff. The judge reads portions of Lewis's motion aloud, including accusations of assault, illegal search, and fraudulent proceedings. Despite the heavy claims, the judge remains unmoved and dismisses the motion, setting the stage for a battle that will continue before a jury.
I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2, moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedy.
Lewis shifts to federal court demands, arguing constitutional violations and citing case law to challenge the court's authority. The judge counters by dismissing the motion again, emphasizing that Lewis will have the chance to argue everything at trial. Lewis continues, citing precedents, but the judge remains firm, closing the door on the legal arguments and pushing the case forward, despite the ongoing resistance.
I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that of the United States Constitution, indicating a clear conflict of interest. I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 US 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion. All right, so you want a trial date? Give me a jury trial date, please, Ms. Memphis. And you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming down.
The 36th district told me to call her the day that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter.
With the motion resolved, the court tries to set a trial date, but Lewis continues challenging. Procedure citing ignored calls, delayed responses, and due process violations. The judge locks in a July 23rd jury trial date, adding a final pretrial hearing. As tensions peak, the judge ends the session abruptly, even misstating Lewis's name on the way out, sealing a dramatic conclusion. Like the video, subscribe to the channel, and we'll see you in the next video.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
I'm getting a jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
It looks like it's going to be July the 23rd.
Before you say that again, Ms. Mathis, just verify it before you say it.
Verify.
Please, the dates.
Okay, I'm just checking.
I know, but you're thinking out loud.
Okay, I'm sorry.
Good day.
Yes.
July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that date. So you trying to play with me? You could dismiss it today. You literally, but
a final pretrial 8:30.
You are literally violating my due process. You can't even give me a written excuse, but you want all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. I do. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial of July 22nd. I am. Date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
I don't know. Mr. Lewis, I'm sorry. Have a very good day. Best of luck to you. All right.